Unions are claiming victory after a landmark ruling they say could benefit tens of thousands of long-term casual workers. The federal court has upheld an appeal, ruling some casuals are entitled to paid leave. But industry groups fear that could mean a back pay bill of up to $8 billion, crippling the jobs market.
Central Queensland's Blackwater coal mine is a major regional employer. Chad Stokes has worked there 6 years through labour hire firm Workpack, technically casual on over 40 hours a week and with a 12-month roster.
You're in a permanent position, and I can't see how they say it can't be.
Now, Mr Stokes and others in his position stand to benefit after the federal court upheld a ruling against Workpack, stating long-term casuals employed on a regular permanent basis should be paid annual, sick and other leave entitlements.
I just want change, so you're in a permanent, stable position. That's and for my kids' future too.
The union's arguing the decision passes the pub test and could benefit a significant portion of the mining workforce.
Oh, tens of thousands, there's no doubt about it. Most mines have 30, 40 or 50% of the workforce engaged by labour hire.
Industry groups say the repercussions of the ruling could go far beyond the mining sector. It's reignited their claims that casual workers around the country in other industries like hospitality and retail could in fact double dip by claiming both leave entitlements and casual loading.
In some industries, that loading in lieu of leave is up to 25%. The Australian Industry Group says at least 1.6 million of the 2.6 million casuals in Australia work on a regular ongoing basis. It says the potential cost for annual leave alone could be as high as $8 billion.
This decision needs to be either appealed or overturned through legislation or regulation as quickly as possible.
Today, the government flagging urgent consultations with workers and employers.
So I think we need to understand how it is going to impact on business, particularly in the context of COVID-19 and business facing its greatest challenges in more than a century, before we rule something in or rule something out.
And that includes leaving on the table possible changes to the Fair Work Act to counter the ruling.
If Christian Porter wants to use the Parliament to provide a protection racket for employers who've broken the law, then he can expect an argument.
It's a classic Labor argument over flexibility, employers' desires to have maximum control and flexibility over their workforce.
Darren Mara, SBS World News.